application of constitution. Sorry for the delay. Yes. So there's a nuanced interpretation of 370 that would my lords be kind enough to turn to documents volume 3, PDF page 13. Let me preface my submission by saying this, that there were substantive provisions of the Constitution of India that were to be made applicable to Jammu and Kashmir, the directive principles of state policy, or even 356. These were all done through the application order. So that's the power under D, with concurrence. Take fundamental rights. That's nothing to do with the lists. So 371B1 and 2 talks of the lists. By law, particular lists. Instrument of accession, only those 4 items. That's B1. B2, other lists. That only refers to lists. That's 370. Then you come to the application of constitutional orders to Jammu and Kashmir. Now, where any law passed under the list, if it relates to instrument of accession, consultation. If it relates to other things, concurrence. But substantive provisions of the Constitution were made applicable. That also with concurrence. And this was being done between 1951 and 1957, when the Constitution came into force. Then the Constitution took over.
This was between 1951 and 1957.
After that also there were application orders. Because 371D continued in operation. So that's why I want to show you the 1954 constitutional order which superseded the 1950 order. And it will show what was done. So nothing was ever done without concurrence, except for those 4 items. Never. Till date. So now kindly see page 13. PDF 13, volume 3. Documents, volume 3, PDF 13.
Page number?
Page 13, PDF page 13, running page 406.
14th May notification?
Yes, yes. Now, kindly see, Millers, by this time the constitution is not in place. But they have superseded the 1950 order. So all orders hereafter were with respect to 1954 constitutional order. Because 1950 was superseded by 1954. So every other order was under 54. Now let me just show that to you, Lords. The following order made by the President is published for general information. The Constitution.
Just 1 second. I just need only 1 minute to it.
I'm sorry.
Get back.
I'm sorry.
I was focusing on something in the Constitution. Which volume would you?
Volume, documents volume 3, PDF page 13.
Yes.
Says the Constitution application to Jammu Kashmir Order 1954 in exercise of the powers conferred by Clause 1 of Article 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, is pleased to make the following order. The order may be called the Constitution application to Jammu Kashmir Order 1954. It shall come into force on the 14th of May 1954 and shall thereupon supersede the Constitution application to Jammu Kashmir Order 1950. Now see what happens thereafter. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that's Clause C, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall apply shall be as follows. Now, preamble. That's the power under D. In with concurrence. So, you see part 1 to Article 3, there shall be added the following further proviso. Provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. Now, this is passed by the constitutional order applicable to Jammu and Kashmir. That's the solemn promise, that has been made, that you will not change the boundaries. And that's with concurrence. And that's exactly what they did, without concurrence.
Mr. Sibbal, why is it that, what is the distinction between the consultation with the government of the state, which is referred to in the first proviso to D, and in clause 1 of B? Because clause 1 of B also refers to consultation with the government of the state, and the first proviso to D also refers to consultation with the government of the state. So it has be a surplusage. There has to be a meaning for why there are two separate provisions in relation to the same.
I must explain that. Because if you look at Muller's B1, it says make law. It's not in relation to the same thing. So it says make law with respect. So it only deals with the lists. If it comes to instrument of accession, those 4 items.
Actually, I was looking at it this way possibly. I mean, just thinking aloud. Maybe wrong, correct me if I'm wrong. B1 refers to the specification of matters on which are covered by the instrument of accession, in respect of which Parliament can make laws. That is B1.
Correct.
It refers only to the specification of matters in the union list which are covered by the instrument of accession on which Parliament would have the lawmaking authority. That is B1.
Absolutely.
Now, the first proviso to D would obviously not cover that category, otherwise there was no need to put the first proviso there.
Well, those only
just see, just 1 second.
I'm sorry.
See, the first proviso also says, provided that no such order which relates to the matters specified in the instrument of accession of the state referred to in para 1 of subclause B shall be issued except in consultation with the government of the state. So the first proviso also refers to the matters covered in clause 1 of B. It also refers to consultation, and B1 also refers to consultation. Now possibly the meaning which can be attributed to the proviso to D is this. D says, such of the other provisions of this constitution shall apply in relation to that state subject to such exceptions and modifications as the President may make. So where the President is making an exception or modification to another provision of the constitution, then the President has been given the power. But what the proviso says is, the first proviso says is, that if the President is making a modification or adaptation in respect of a matter which is referred to in clause 1 of B, namely something covered by the instrument of accession, then you require consultation. The second proviso then says that no such order which relates to matters other than those referred to in the last paragraph will be made except with the concurrence. I was wondering, just thinking aloud, what D says is that if the President is making an exception or modification in the application of any provision of the Constitution to the state of Jammu and Kashmir, then you require either a consultation, first proviso, or a concurrence in terms of the second proviso. Right? Now what happens if the President is not making any exception or modification at all? Does that require either a consultation or a concurrence?
Yes, according to me, yes, but let me explain.
Because this adaptation order which you showed us, for instance, of 1954 makes modifications. Preamble will apply subject to these exceptions. Directive principles will apply subject to these exceptions. So what happens if the President is not making any exception or modification at all? Then do you require a consultation or modification in terms of clause B?
May I, Malad, then?
Yes.
Since you're
yes.
Now, let's kindly look at B1 first for a minute. It says the power of Parliament to make laws for the said state shall be limited to matters in the union list and in the concurrent list. It doesn't say anything more than that. It specifies the lists under which they can make laws.
Which?
Okay, no, that's right. They are not. The law has not yet been made. It's only the power
declared by the instrument of accession.
So, Manoj, only the list communication.
Right.
I'm not talking about the law has not yet been made.
No.
So they are correlating the making of the law to the items in the lists. When it comes to the instrument of accession, it has those 4 items. When it comes to other matters, it is in the concurrent list, not in the state list. But they are not setting out what laws to be.
One very important thing is that clause B does not confer the power upon Parliament to enact law for the state of Jammu and Kashmir. It limits it in certain respects. The power of Parliament to enact law is under 245 and 246.
246 will not apply.
No, but the power is somewhere else apart from B.
No, right.
B recognizes the power of Parliament to enact a law because it says the power of Parliament to make laws for the state shall be limited. It's a limitation.
No, it's a limitation.
But Justice follows to say it's a limiting clause.
Yes, square that list only means square that list.
So if it is a limiting clause, the power of Parliament to enact the law is traceable elsewhere.
No, brother.
Can we say that 370B gives power to Parliament to enact law? No. It limits the power of Parliament to enact law to a certain extent.
I was trying to explain what
yes.
is not put to be. Please allow me.
Yes.
What I was trying to say was that here, what the clause says is that where the lists in the instrument of accession, right? Parliament may make a law, but that will be in consultation.
it's a double limitation, Mr. Sibbal. See, the first limitation is the chief mentioned.
And let's
power of parliament to make laws for the state can be limited to.
Yes.
What is it limited to? To matters in the union list and concurrent list. So first part is matters in union and concurrent.
Correct.
But second qualification, which in consultation with the government of state, there also you are right, to that extent you are right, it is in consultation with government of state, are declared by President to correspond to matters specified in the instrument of accession.
Correct.
Governing the accession of the state.
Correct.
So such parts of union list and concurrent list which form a part of the instrument of accession, because everything else doesn't form a part of the accession. The whole list doesn't. Right. To that extent, Parliament can enact law. Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely.
That's how I read it.
That's what I'm saying too. But they are not, at that moment the law is not made, they are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those four items: communications, defense, external affairs and ancillary, which I showed to your Lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Malad. That's how I'm going to.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Malad's 1 is integration into India, and Malad's the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. We're talking about preamble, we're talking about 356, we are talking about fundamental rights. Each of those orders require the concurrence of the state. I will show that to your Lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the President may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read. Provided that no such order, that is no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your Lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference.
Yes,
it's entirely different.
Yes, but
Yes.
So, Attorney General, that too, constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibbal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than one and
other than 1 and 2. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of the concurrence of the state. Alright? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence. Even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
correct.
Now, the question is really which is a more plausible construction.
Actually, if your Lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibbal, the Chief Justice, that constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render three OCOs completely. C will become OCO.
C is
the provisions of the Constitution.
Yes, C is something different. C dilutes the article itself.
C, Mother, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Mother. I'll be able to show that to your thoughts.
B is 370 and C is Article 1.
And 1 is Mother's integration. So that can't be touched. Part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched. C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. It doesn't say it touched.
By now, your Lordship has, in fact, there's your Lordship something interesting. Because I looked at the original Constitution of India. Judgement will show it to your Lordship. It's only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your Lordship, they held in Keshavram Bharti itself. You can't look at these notes.
No, in the sense that the marginal note doesn't control the meaning of the text.
And 3, Article 3. Marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, coming to that one, let me show.
Yes,
Very
yes,
fascinating.
yes.
It takes a bit of time, but it's kindly number 370 presidential order.
Yes. That 1954 order.
50.
That is another
50. Same volumes.
1950 or 54?
No, Malas, I am coming to 50, Malas. Liquid tech. Volume 3. BDS paid 4 months.
This is what you are reading as 13? No,
That is the 54 order. I am coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. The other was on at 13, this is at 4.
So that's 4. Okay.
Yes.
Are you referring to CO number 10, Mr. Sibbal?
Yes, absolutely. Well, let's kindly see the index of this, 3 pages earlier. Yes. See what has happened now. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes.
The first page of the volume.
That's right.
We are looking at
There's a whole index of all the orders.
orders issued. Yes. Serial number 1 was superseded by serial number 5.
Too specified.
Now read it with me. The order may be called the Constitution Application to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of Clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the Union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state, for the purposes of B1 of Clause 1 of 370, the matters specified in the first schedule to this order, being matters in the Union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your Lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India, and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage. That happened later. Then you went, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, at PDF 6, page 17. I just for my Lord. PDF 6, page 17. Kindly see exceptions. Article 70(1), provisions of the Constitution applicable. So there was no doubt on this issue. Entirety of Part 5. Part 5, 72, 1C, 72, 3, 133, 134. Those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications with the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modified 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what's the effect of clause 2 and 3 of Article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) says refers to the power of Parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the Parliament can enact a law on the concurrent list.
It's because of 1B, mothers. It only tells you the methodology, mothers, that's all. The point is, what my Lord is putting to me is, the President can exercise powers under 370, derogates a modification. That's an exercise of plenary power. That's what my Lord is putting to me. But mothers, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone, it's the substantive interpretation of 370. Kindly see the first column, mothers. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely, that's our submission. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply now. It's not in the second schedule.
Let's go to the
54 order.
54 order.
Yes, that's volume 3 again, page 13. That's it. 30 PDF. Yes. Yes. In exercise of the powers, you also have that? So exercise of the powers conferred by clause 1 of 370, President with the concurrence of the government of the state of Jammu is pleased to make the following order. The order may be called the Constitution Application to Jammu and Kashmir Order. So, Malad, supposing the entire constitution was to be made applicable, Malad, it would require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So, any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence, instrument of accession and concurrent list. And Article 1 and 3 are out of it. So kindly see, mothers. Clause 2, the provisions of the Constitution which in addition to Article 1 and 370, in addition, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows, the same pattern.
So the exception made here is the entire constitution is adopted subject to the
Yes.
modification
Yes.
made there.
Unlike
the
other than 1 and
1950.
3, other than 1 and 3.
1 and 3 is already there. Unlike 1950 order, which had specific articles were made applicable, now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying 356.
It's part by part, not two minutes. Part by, see part 1, part 2, part 3. It's part by part, it's not all.
Is 356 specifically excluded
No, at this stage.
at this stage?
Yes. Excluded.
It would be excluded at
After
this.
part 5, you have part 9.
Yes, come to page 15. 356 is excluded.
Yes.
So the entire constitution was made applicable by the 1954 order,
Well, they said,
except to the extent of exclusion.
well, this part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.
The Sibbal, my learned brother may be, with respect, right. I'll tell you another reason. I'll give you another, just apropos what fell from Brother Sanjeev Khanna. Just see now part 3. First, we'll just see one small provision, clause 2. Clause 2 of the order of 1954.
Correct.
Yes,
It says the provisions of the Constitution which,
yes.
in addition to Article 1 and Article 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications shall be as follows. Now, one thing is very interesting. The word only, which we found in the 1950 order, has been deleted in the 1954 order.
Right,
So only goes.
yes.
Now, let's go to part 3 for a moment, and just to test the hypothesis.
In just one part. Yes.
Now, just see clause C in
Yes,
part 3.
Clause, yes,
Right?
I got it, mother.
It says in clause 3 of Article 16, the reference to the state shall be construed as not including a reference to the state of Jammu and Kashmir.
Correct.
Now, if you see Article 16(3) of the Constitution,
Yes.
it says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local authority within a state, or any requirement as to residence within that state or union territory prior to such employment or appointment.
Right.
Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
Yes.
what is the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Miller's other clauses in respect of clause 3 of the Constitution came into the J&K Constitution later. And I'll show that to your Lordship.
But is it your contention therefore that
Entirety of 16
but
applies.
16(1) didn't apply to the Jammu and Kashmir?
It did apply, it applies.
The part which is mentioned,
So how did it apply then?
no, part 3 applies in full. When it says part, your Lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was column 1. So in the second
That's what I was saying. See, in the earlier, the manner of printing of the two notifications
Yes,
is like
yes,
this.
that's all. That's very
The first one,
has been
there is a column, it is an article.
Yeah.
Then what is the exception sort of
Correct,
carved
correct.
out?
And the modification. Now it's
Modification exception carved out.
So now it's
This, the way it is printed as I see it,
yes.
when they say part 3, it means part 3 applies, but
these exceptions and
one
modifications.
column of modifications which were there
Yes.
are specified underneath it.
That's exactly
That's
correct.
exactly-
Nothing, no difference.
Other than what has been exclusively excluded.
Yeah.
The rest of the part 3 applies.
That's correct. That's all that is. That's all.
This is simple,
Like
I
16,
think,
1 and 2 applies.
this is simple, just come to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay.
The provisions of the Constitution.
Yes.
This means the entire provisions of the Constitution.
Page 10, your Lordship. PDF page 10?
Yes,
Yes.
that's the notification, 14th May 1954, 2, clause 2. The
Page
provisions
13, not 10.
13 of the
of page 30,
Yes,
yes,
30.
yes, page 30, you're right. The provisions of the Constitution,
Yes. Yes.
which in addition to Article 1 and 317, Article 370,
Yes.
because that's covered by
Yes,
3.
yes.
Now the provisions of the Constitution refers to the entire provisions of the Constitution.
Correct, correct. Yes.
Shall apply in relation to the state of Jammu and Kashmir. Full stop.
Which?
Second-
The word
second-
left the word out which.
The, Yes, I'm aware of that. That second part says the exceptions and modifications subject to which they shall also apply shall be as follows. So thereafter, the exceptions are carved out with regard to each part of the provision of the Constitution, which are either not to be applicable or applicable with modification. And if you go down, it specifically says 356 is excluded. In case this was specific inclusion, they need not have specified 356 is excluded, because by implication 356, if not mentioned in the schedule, would have been excluded.
With the greatest respect, when you say kindly read it, just see, kindly see part 18.
The very fact that some articles have been
Kindly
included.
say page 18, kindly see page 18, PDF page 18,
Yes.
which is this. See part 18, 352, the following new clause shall be added, above that,
Correct.
part 18,
Correct.
and therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
Like part 18 applies, for example, part 18 applies, the modification is specified below that.
Yeah.
Then small clause B, 13 part 3, small
Well,
B.
therefore, there is no dispute on
The entire
that.
Constitution has been applied. They will
357,
accept what.
exactly. So these three articles of part,
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply. They are enumerating the provisions, that's all, Madam.
the next after that is what are the modifications?
Yes.
Or what is omitted. So mostly they are modifications, but some are omissions. For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
other than this will apply.
That's right.
The approach is, instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But ultimately,
What about those parts which are not specified as parts?
They don't have.
That is a problem. I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
well, that's what, the only,
And this is significant.
I think 15.
PDF 15. The part your lordships are referring to is? Yes. Yes. So part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification. But where there is modification, then
that's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding of any authority then. Now we are saying no, that is all wrong. Actually, everything
we're not
applies.
saying, we just
And,
discussing.
and you don't need consent.
So Sibbal, as I see it, as I said, every order extended different parts of the Constitution
That's right.
to Jammu and Kashmir. Now, if a particular provision is a modification, it says so. It may be by provision wise,
Yes.
or it may be part wise,
Yes.
it may be by any method.
Correct.
But it keeps on extending by order which are passed. So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes.
with certain modifications.
That's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only. And in any case, Madam, 1 and 3 are 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Madam, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the Constitution. So we can, Madam, interpret the orders any which way you want, but it cannot touch 1 and 370.
two major points to my mind are this. One is the submission that Article 370 has acquired a permanent feature of the Constitution. That's the debatable issue, which both sides will debate. Next is suppose it is not permanency. Then what is the manner of abrogating Article 370? Is that procedure followed or not?
That's correct.
The only two issues are
Correct.
the whole
I'll hope and try and convince you that it is permanent. I will try and convince you. I know, but your lordship says it's debatable, and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this point out.
It's really debatable. But I tell your lordships, mothers, why it is permanent. Mothers, now, for the moment, mothers, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether the procedure has been followed or not followed. They will say we followed the manner of application.
Absolutely.
You will say not.
Now, mothers, so far I've only referred to provisions of this Constitution. But, mothers, your lordships will have to look at the Constitution of Jammu and Kashmir. Because that Constitution, mothers, was framed and cleared in 1957. So, mothers, mothers, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, it can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah, but I'm sorry, my understanding is right. Before we go to that, let us kindly see the volume 1, PDF 132.
You are wanting us to go to PDF 1 now.
PDF
Volume 1 page, Mr. Sibbal?
Mothers, volume 1, page 131. 132, mothers. Now, mothers, kindly see, this is the Constitution of India as applicable to Jammu and Kashmir just before abrogation of 370. And you'll see
Which page?
page PDF 132.
In the same volume?
Yes, volume 1. Volume 1, mothers, not 3. One second. Now, mothers, your lordships will see the table of contents at page 43 first.
Which page? You said 132, 43, which one?
Sorry, 43 first. Mothers, it's a table of contents are set out.
It will take a little longer to get to it.
Sorry, mothers, sorry about that.
It's not fault, Mother. We have wrong page.
Page 56, sir.
43. By the contents, volume 1.
Yeah.
Looks somewhat like
There is one little improvement which we have to make in our written submissions format. In fact, I am just in the process of issuing a standard operating procedure for filing written submissions on all matters before CBs, which is that the index should be hyperlinked. So that will be much easier for all the lawyers and for us also. We go to the index and just click on the hyperlink there.
Please, what you are saying?
yes, index.
46 is the index.
Yes. Now, kindly see, Mother,
Index actually starts earlier. Index starts from page 43.
Yes, 43. No, 43. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there is no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016. As it's written.
Now you see here, Mother, after part 6, you have part 11.
page is that, Mr.
Well,
Sibbal?
part 6 is at page PDF 48, and the next is yes. Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only, the word which indicates what these other
That's really. Now, in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember, yes, right.
Publication or government publication?
It's not a government publication, but this is not hopefully not in dispute.
So, Mr. Sibbal, you're right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the Constitution to Jammu and Kashmir. They never treated it as if all provisions apply. So really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the Landeji on that.
Now, we move on to what happened in 1957 when the Constituent Assembly drafted this constitution and was adopted. Right. And remember the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want.
57, what happens with 57? Let's see then.
Yeah, but I'm just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and like any other state. They chose not to. And you will see that in the Constitution itself. I'm sure, it's better we look at the Constitution.
There is no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there, otherwise where was the occasion to abrogate it? Only issue is whether it requires a permanent character which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct.
That's the first part of the argument as I understand. Correct. And in the alternative argument is, even if you don't accept my first part of the argument,
The methodology was wrong.
was wrong.
I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is, continues, always. Second part is transitory, because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary, while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner
Yes.
whereby some part will go away or become
Yes.
odious, and some
some part becomes OTOs because in 1957, some other part becomes OTOs later on. You say one has a permanent feature. That is our
The
argument.
Constituent Assembly effectively had a choice to exercise 3 or to allow 1
Till 1957. Your argument is all these choices were available only till 1957.
Yes, that's right.
That is our argument.
So much. No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the President as the Maharaja of Jammu and Kashmir, acting on advice of the Council of Ministers for the time being. Now what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there. It is part of the constitution. I'll show that.
This explanation was introduced in 1952.
Leave it. Let's you can.
Their case is that 2 and 3 may seem post 57. But some of us people understand unit. Because if we read clause 2 carefully, so this is that difference of unit. So your submission.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the government.
67?
Yes, 1965 order.
65. So till 65 did the Maharaja continue to
Yes. Then
Separate powers of Sadr-e Riyasat.
Yes.
But
ultimately,
equivalent of chief minister is called the prime minister.
yeah, that's
Long period of time.
correct. But in
Those
65,
governments
it was the
were,
governor. There's an order to that effect. So be that as it may, I think we're traveling a bit too far at the moment.
It's not anything that was done at the Senate. Take it.
Now kindly see, the preamble of the Constitution, your lordships will find, volume 2, PDF page 16.
Now we are looking at the J&K Constitution.
That the Constitution of India is applicable under J&K Constitution. J&K Constitution.
So that is volume.
Volume 2, PDF page 16. Yes. No, for J&K.
You want us to go to page 16 of the
Page
J&K
16. Yes, the entire volume is there. Lordship has the preamble.